So I've been paying attention to this prosecutor's court cases for a while now, and I've noticed a few things that I'm going to make accusations about. But right now, I just want to inform and let you guys know of what actual misconduct that she has already recorded and published to the public, and then also too that she's absolutely corrupt. It's I know here on the description of this video you said possible corruption. I'm gonna prove that there's actual corruption, and it's recorded, and you've already seen it. You just don't know it yet. But then I'm gonna show you why I've been watching her and what I think that she is doing. But Lawrence Accountability is going to have to watch it, and because he knows I'm from Texas. I don't know any of the laws. And so anyways, this is for you, Kansas News, and for Lawrence Accountability to watch.
Watts.
And were you involved with the defendant in this matter in an incident?
Yes.
And what date did that incident occur?
Oh, I don't have the date off the top of my head. It was September, I believe.
Is it a true and accurate depiction of what occurred on June 27th of 2023?
Yes, ma'am.
Okay, all the court cases I watch, if they're not sure of the date or something, then the lawyer says, well, you want to look at your police report and make sure it's accurate or whatever. She just totally skipped over it and let him get it wrong. I think this is because it's going to help his injury case, because according to him, the reason they didn't accept his workman's comp is because he waited too long. Which is absolute bullshit, and I'll explain that one later. But the real problem comes when she introduces in the evidence. So I don't know how much you know about courts or whatever, but the discovery phase is different in different states, and I'm not sure about Kansas's, but what normally happens, especially on a Zoom trial, is that there's a way to upload evidence that they can both see, so they're aware of what's going on with the evidence, and when it comes time for court, they mark them as exhibits. So if you say Exhibit A, then the judge and the defense, everybody knows what you're talking about, and they're supposed to be clearly marked and numbered or whatever, clearly demarcated, this is this, and so everybody has knowledge of it. All right. So instead of doing this properly, she tries to enter in her entire laptop as evidence, which the judge accepts. And I know you're thinking to yourself, well, what the hell? Now the defense and the judge all have access to everything that's on her laptop, all the footage and all the stuff, right? That's what you would think. Well, first, here's a judge doing a tutorial for other judges on how to go about the process of discovery and getting body cam footage in there and, doing it properly. Yeah.
Venue to show stuff to people that are in the meeting. That's the meeting, the share screen. And in the virtual trial, as Judge Phelps explained in the very first session, your exhibits have already been pre-marked. And you pre-marked them with neutral names, but they've been pre-marked when you uploaded them into ShareFile and you submitted your joint statement of evidence. Opposing counsel has access, so you don't have to be thinking about showing them, but you have to make it very clear to opposing counsel and to the court what it is that you're asking the witness to look at. And the witness can't look at it on the big screen because the jury can see that as well. We're talking about some solutions on that. Now, you still have to lay foundation and you still have to offer it. And when you publish it, you do that, of course, by sharing your screen. Two tips here. One, do not use ShareFile, the document out of ShareFile, to show it to the jury. You should have an exact copy of what is in ShareFile on your computer. Use the one that's on your computer. It better be an exact copy.
This part is important. It should be an exact copy on the hard drive of your computer. Exact copy.
Use your computer to actually share the screen. And don't share your entire screen. Share the application.
And this is where she screwed the pooch, because we got to see everything, and I'm going to point it out to you. And once you see it, you guys are going to have a heyday with this shit. And then that's not even the accusations that I have on her.
Adobe should pull up Adobe in share screen, not your entire screen, because then we can see all your emails and we can see all your icons.
Absolutely right, Judge. And we can see other shady shit that you're trying to do. And we can also see the dates and times that certain files were added or modified.
So share it from your computer, not from ShareFile, because it'll sit there on WIR, and share it and share the application that you've opened then, not your entire screen. So let's now talk about the dance in this environment. Here's how it works. Instead of the whole mark, show, hand, here you direct your witness to the attention to the exhibit number. Now, it should already have been uploaded in ShareFile so that opposing counsel and the judge, we can look at it. We know what you're talking about. And it has a name, which is the exhibit number. And it should be a neutral name. And bear in mind that if you upload them with highly suggestive names, you and your judge are going to have a conversation about that. So try to stay away from really argumentative names, but simply descriptive names. The witness should have their own copy wherever they are. Now that can be an actual physical copy that you've mailed to them. It can be a PDF, or it can be a Word or an electronic version that you've emailed to them. If you're in the middle of trial and push comes to shove, you're trying to figure out how to get them, you can email it to them.
And as far as I know, that didn't happen. I'm under the impression that Mr. Walker Jr. didn't see any of this until the date of. But either way, there is a way for her to do it, and she knows about it.
Or you can, Zoom itself actually has, in the chat function, it has a share file section in which you can see they're displayed on my screen. It's down on the bottom. It's hidden behind a little button that says file. You click on that, you can share from your computer. You may have to ask your judge to open up share because many of our judges keep the chat function closed.
And that's another thing. The judge is supposed to be running the show with the computer, not the district attorney or the county attorney or whatever the hell. But here's some footage of her proving that she knows that this exists.
Are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
Therefore,
if
he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Miss Gillette,
So yeah, their particular file sharing program is called Odyssey, and if you didn't gather from what you just heard, that's how they screw people into bench trials. What they do is when you go pro se, they don't actually tell you about this system, and then whenever there's 7 days before trial, you haven't asked them for a jury trial, then they strong arm you into one.
issue on not filing a.
Okay, now back to let's watch how the rest of this plays out, and then I'll show you. And if you guys already knew all this, man, I'm sorry. I don't mean to go back over it, but here we go.
And at some point, did a struggle occur with him?
Yes, ma'am. As we were walking into the booking room through the doorway.
Okay. Now, when that struggle occurred, were you injured?
Yes, ma'am, I was.
Did you end up seeking medical attention at the ER?
Yes, ma'am, I did.
Okay, this part is important right here because of the accusations that I'm going to have after I show you guys this. But notice the text up on top. So I think this is the start of the testimony leading to more serious charges against the defendant. And notice the ... and the capital think. And
did you end up being put on leave as well for your injury?
Yes, ma'am.
Did you help download the security video and submit it to the state as part of your investigation in this matter?
This is the beginning of the setup. The sheriff lady, Miss Bliss, is in on it. So you'll see what I'm talking about. But she needed to ask this question. She needed it to be heard that Miss Bliss helped her with it, because she's about to help her again whenever she can't get it to play.
Yes, ma'am. I downloaded my body cam and submitted it.
And was there also booking room camera?
Yes, ma'am. Sheriff Walker, I believe, downloaded that for us.
And is it a true and accurate depiction of what occurred on June 27th of 2023?
Yes, ma'am.
Your Honor, I have admitted my laptop. Your Honor, I have admitted my laptop is the second county attorney on the screen, and I would.
And that's the part that I first noticed she was a lying piece of crap. So you see the boxes, how they're organized, 3 on top, 2 on bottom. If there's 4 people, it should be in a square. You know, they'd reorganize. There wouldn't be that third one on top. So there's another person on this trial that has a laptop open that we can't see and hasn't said anything behind where all that information is on the top left. I'm not sure about the legality on that, but that doesn't sound legal.
I'd like to play the video for you and admit it as states.
Again, notice the text on top. We would surely like to see it with capital Shirley and an exclamation mark.
Mr. House?
No objection.
Very well, you may.
And see, this makes me think the lawyer for Mr. Jr. is in on it. But then again, if he did get discovery, then he wouldn't have an objection. But if he didn't get discovery, then he would say, objection, absolutely not. There's no way we're going to watch that if we didn't have it first.
Stage 1 is admitted, and you may publish the video.
States 1 and publish the video are the 2 phrases that make me think that's the only thing in evidence and only thing in discovery. But here goes. This is definitely Jill Gillette's laptop, because that badge on her background right there has her name on it. And you can't tell from this shot right here, but you can go back and look on the video and see that it is.
It's admitted, and you may publish the video.
This is what that judge was saying on the tutorial. Don't share your screen because we can see shit. So you notice with the video that she's going to try to play is from her computer, drive F, right? Or USB, Universal Serial Bus Drive F, which is her computer technically. Well, that was a weird sound. That clicking sound kind of sounded like somebody was opening up a DVD drive and sticking in a CD or something. But it's 2024. Why would somebody do that?
Did anywhere was found with this video on the booking room?
Okay, that was Jill Gillette's voice asking Miss Bliss a question, but she muted her screen. We shouldn't be able to hear that, right? Okay.
Miss Bliss, Officer Bliss, do you recall if there was sound in this video?
Yes, ma'am, there is.
If we could go back to the beginning of this video with sound.
I know my body cam footage had, but when I had it, it had sound as well, Your Honor. Jill, you might have to play it through the old media system, the old media player. I think that's the problem.
Boom. Now it all makes sense. That clicking sound was her putting in a rewritable DVD, which she has the other clips on that she wants to show. And also, she submitted her laptop into evidence, right? Well, after she ejects that DVD, and there will be no evidence of anything on there because it's all on the DVD that she has. And check this out. Each one of them, so the way they're marked is like time. She didn't rename any of them with neutral names or anything. But also, check out the date that they're modified. Watch this. Bam. So she didn't rename any of them with neutral names or upload them to the proper program. What she did was that night at 10:45 and 10:53 and 10:23, she took a DVD-R and then took little clips from the longer full-length videos and took the clips that she wanted and made her own copy of them on a blank DVD and for her own use. Actually, for use at this trial, which she didn't even give them a chance for discovery, and then tried to play these clips as if they were public record now, which they technically are some kind of record, but just a real distorted type of record. It's illegal as hell. I'm sorry, but there is no way to explain that as an accident or as a mishap or as I didn't know, I couldn't do that, officer, or whatever crap. I mean, the fact is, it's an AVI file. What happened is her player doesn't read files in AVI format because they're old, and that's the struggle she was having, which actually brought up something else. That microphone sound, that feedback sound or whatever, I think that's because the deputy and her were close to each other. I think their two computers were close to each other. If you listen, when she's asking her about it, it sounds like the attorney's in the background, which I think she is. But anyway, I can't prove that. So I haven't put a video on YouTube in like 10 years or even longer than that. So I'm going to have to make another video about the accusations that I have against the Jill Gillette and the couple judges. But I don't think my phone's going to be able to handle this. So, but that should be enough, man, like to at least get something going, dude. I really, really, really hate people who lie. And I really, really, really hate it when it's anything that has to do with our justice system or whatever. And, anyways, I'm going to cut this one off and then I'm going to make the other one for you guys. Later. Oh, two other things I forgot that are a matter of public record. She and this judge and the attorney for Robert Walker Jr. are all involved in a lawsuit. Here's what I found on it. A United States judge is ready to conduct proceedings, it says. Also, if you read this is complete bullshit. She just wrote a statement. It's not a complainant statement or somebody that was in fear. She wrote a statement of what she saw, and then if you just look, the very last sentence where it starts, I was terrified, blah, 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 and it says, and my voice. Dude, that looks like somebody else's handwriting. It's smaller. The words are spaced further apart. That very last sentence isn't even her handwriting. Here are some other pieces of information. She was married, and her middle initial is R, but she took her husband's last name, Etheridge. Also, if you look closely, there's an Amanda Walker who graduated in the same class as Jill, and it shows Amanda Walker, when I looked her up, is a, well, it's right here. IRS or something? I don't know. And this is just showing that the judge presiding over the case was appointed to an elected position, which is just weird. And this is a complaint. It's filed with the disciplinary administrator against Judge Joe Lee in this trial from 2006, 2004, 2005 for losing his license to practice law.